another way to protect certain aspects of traditional knowledge relating to plant varieties is through the Protection of Plant Varieties and Farmers' Rights Act 2001. Under this legislation, benefits can be claimed by those indigenous tribes and communities wherein their genetic material is used in the development of a new variety. So whoever produces new variety based on earlier varieties wherein certain traditional knowledge or certain other aspects of biodiversity is involved, then the earlier originator would be required to be compensated. So it is something certain kind of a benefit sharing requirement that is under the Plant Varieties Act. Similarly, farmers would always have the right to save, use, resow, exchange, share or sell his farm produce in relation to non-branded seeds. Now this requirement specifically allows farmers to get certain kind of protection against infringement of plant varieties. Farmers can also register their own varieties. Now this is a kind of positive protection that the law provides to farmers, wherein their own varieties which is based on certain existing traditional knowledge can also be registered. Geographical Indications Act 1999 is one of the new legislations that is required to protect certain aspects of brand relating to geographical relating to products that have certain attributes which can be traced to a geographical location. Now geographical indications as such and per se may not provide full protection to traditional knowledge and products associated with them, but it definitely helps them to protect the unique name symbol of the product in which the TK persists. Now this may be suitable to a limited extent since GI acts as an authenticity quality of the mark for quality reputation characteristics of the product. It is a kind of collective property philosophy and hence it acts in a way to protect certain elements of the collective property notions involved in traditional knowledge. Now applicants can be any association of producers and must represent the interest of the producers. Now this is a kind of unique law that can protect certain aspects of traditional knowledge. The common law regime of passing off can also be used in certain circumstances where products based on traditional knowledge are actually misappropriated and used, wherein the other person who infringes on the mark or on the name would sell it as arriving from the source of others, in the sense that he would sell it primarily to show that it originates from the person who has originally produced the product based on TK. This remedy is even otherwise available in case of other kinds of infringement of unregistered trademark, which can be extended to the products that involve traditional knowledge too. Similarly, the scheduled tribes and other tribal forest dwellers Recognition and Forest Rights Act 2006 grants legal recognition of rights to traditional forest dwelling communities in relation to certain kind of biodiversities. Now this is a very important act which pertains to forest dwellers and their traditional rights relating to collecting of forest produce. Finally, India has come out with what is called as a traditional digital library, traditional knowledge digital library. In this case, measures are taken to prevent misappropriation of traditional knowledge, and what happened was, after the turmeric and the neem episodes wherein patents were wrongly granted and subsequently revoked by USPTO, it was thought by the Indian government that it would be important to document these and create a wide repository of existing knowledge and create it in different languages, so the different patent offices can use those libraries and can either revoke the grant or may not grant based on the existing prior art that is mentioned. So primarily the TKDL is translated in several languages: English, German, French, Japanese and Spanish. Traditional knowledge resource classification is a standard taxonomy that is used for classifying these. TKDL covers over 2 lakh formulations which have been taken from Ayurveda, Unani Siddha and Yoga text. Now this project is quite impressive in the sense that a lot of existing material has been located and translated into identifiable text. Now the PLIDET project, and it's clearly not a comprehensive documentation of traditional knowledge. However, excess MOUs have also been signed with the EPO, JPO and USPTO. Now this traditional knowledge digital library is held in confidence and is not clearly available to the larger section of the public, but special access agreement are granted to EPO, JPO and USPTO and some other patent offices. Free access to patent offices has been criticized by a lot of people because the collection of these resource and documentation involved a substantial amount of money of the Indian government. Furthermore, free access has also been criticized on the ground that it does not factor in the actual knowledge that is already ingrained in relation to TK associated with biological resources. One other important aspect in relation to traditional knowledge digital library is that there is no effective mechanism to prevent leakage. Now these databases, although are granted through MOUs and access agreements, but whenever a patent applicant has to make an application in relation to a biological resources, and if certain certain description mentioned in the invention somehow overlaps as part of prior art that is mentioned in the TKDL, the patent offices will require to give reasons for rejection, and in providing reasons for rejection the patent offices may actually use and transmit the knowledge from the TKDL library and mention them as reasons for not granting the patent application. So ultimately the constituency, that is the patent applicant, gets hold of this knowledge by virtue of certain reasons that are cited in the rejection letter or the reasons that are mentioned by the patent offices for not granting the particular patents. So widely, TKDL has been used to a certain extent, but there is a whole lot of potential for abuse also. So with this we conclude this module on patents, biodiversity and traditional knowledge, including we have studied how it is difficult and ambiguous to define traditional knowledge as such, and the attempts at the WIPO to define traditional knowledge. We have also looked into what is the requirement under Convention on Biological Diversity, how does it view traditional knowledge and how does it view the rights of indigenous communities, what does Nagoya Protocol deal with, and how access and benefit sharing mechanism is clearly outlined in the Nagoya Protocol, what are the particular kind of conflicts or complementarities within the TRIPS and the CBD, and finally we also discussed Indian provisions through various legislations as either in relation to positive protection of traditional knowledge associated with biodiversity or in relation to misappropriation of traditional knowledge associated with biodiversity.